Hi, welcome back. Attorney Steve Vondran. Welcome to another exciting episode of Vondran Legal Hour. All right, so in this video, we are talking JD jargon. JD jargon, 30 Latin legal terms you probably need to know. Okay, so I decided to do this video because there's like so many Latin terms that I think, especially if you're in law school and you go, oh my God, there's like so many Latin terms. How do I learn all these? Well, I'm gonna go over the ones that you probably need to know. There's a lot of them that, 14, 15 years later in my legal practice, you hardly ever see them. So I'm gonna go over the 30 that are important. If you're a law student, these are 30 that might show up on your bar exam somewhere where you can show how impressive your grasp of Latin is. And so without further ado, let's dig in, okay? All right, so number one, ab initio. Ab initio, what does that mean? Means from the beginning. That means it's often something you'll see in a legal opinion that says something was void, ab initio, void. And that really means from the inception, inception. So, for example, you might have a void contract due to fraud. So you may see a legal opinion that says this is void ab initio. Okay, that's a nice one to know. All right, actus reus. What does that mean? Sounds like a Greek movie of some sort. This is a criminal law term, and it means guilty act. And it usually goes along with the guilty mind, which is the mens rea, to prove criminal liability. So when you're taking criminal law, you'll usually find most statutes require some sort of criminal intent. Some don't. There are strict liability offenses. But the actus reus is the guilty act. That's really easy to understand. And the mens rea is the guilty mind. You put those two together, you have potential criminal liability. Okay? Next one, ad hominem. This is something where you may be in court and you make a great, brilliant, dazzling argument, and the opposing attorney says, oh, Mr. Vondran's the worst attorney that ever lived and existed and walked the planet. And so what they're doing is they're not addressing my argument, they're attacking a person or their character. That's what we call an ad hominem attack, okay? Next one, affidavit. What's that? Affidavit means sworn facts. These are sworn facts made by a person under oath, which is under penalty of perjury. Okay, so this is admissible evidence in court. Now, usually an affidavit, it's very similar to what we would call a declaration, and that's where you're telling the court that you have personal knowledge of certain facts, and that if called to testify, you could and would testify as follows, and then you put down the facts that you're willing to testify. So that's an affidavit that becomes, because it's under oath, something that can be deemed admissible evidence in court, and people use it with their motions and things like that. Now, versus a jurat. Now, affidavit versus a jurat. Every now and then you might hear the term come up, jurat, I need a jurat. Well, that's a sworn statement in front of a notary. So that a jurat would be where you are swearing, taking some sort of oath in front of a notary, and the notary is basically noting that with the notary stamp. That is affidavit, another Latin term that you need to know. All right, here's another one, amicus curiae. That one sounds fancy. I like the sounds of that. What is that? Refers to someone writing, this is what it usually refers to, someone writing a friend of the court brief, even though they are not a party to the action. So say there's a big copyright case going on in DC circuit courts or whatever. I can write a friend of the court brief, or a lot of times you'll see this in big Supreme Court cases, for example. Somebody will write an amicus curiae brief. Okay, so it's friend of the court. The goal is to influence the decision maker and point out things that the court may not be aware of. Take, for example, there's like a lot of different issues. Maybe there's something on, there's a big case on music piracy, let's say. There's a lot of different angles to the music business. A good amicus curiae brief can help point the judge out, point some things out that perhaps the judge is not aware of. So that's the purpose of that. Also could be someone being called, like an expert, someone being called to give special evidence or special testimony before a tribunal. That's a good one. Amicus curiae, put that in your toolbox. All right, bona fide. I think we probably know what that means, but just in case, it's good faith. Bona fide, good faith. Like you may hear this in, we heard this a lot in foreclosures when somebody was a bona fide purchaser for value at a foreclosure auction. The people that are bona fide purchasers get, a lot of protection under the eyes of the law because their offers were made in good faith. It's bona fide, okay? So there's another one for you. Moving on, de minimis. Okay, de minimis is minimal. It means basically minimal. And the old maxim in the law is the law will not concern itself with trivial matters. The law will not concern itself with trivial matters. So there you may be involved in a case where it's something so minor that you're going like, why on earth am I being sued here? I mean, I get it, but I mean, they're talking about a matchstick or something. We're talking about something minor here, very minor. This may be something you want to bring up. De minimis is another great Latin term. De novo, this refers to anew, it stands for anew, and this is where you may have a trial de novo where a court can order a new trial, basically starting from scratch, for example, where a verdict could not be reached in a trial. So that's a de novo. Sometimes you may hear this will be a de novo review, and that's what they're referring to. So another great Latin term to know, de novo. Dictum, I love this one, and this is important because in law we have legal precedent and then we have things that are dictum. So you may have a case that you're reading and you go, ooh, there's some great language in there for me to use in my briefs. But the other party may say, well, judge, yeah, that was dictum. It was not central to the holding in the case. It was just a judge sort of talking about something that was not central to the key issue in the case. So that is what we refer to as dictum. Another way to look at that is it's a little off point. If what we say, if a case is exactly the same as a prior case and the judge is ruling on that and issues a holding, that holding is the rule of law. Dictum is, as I say, you can cite it, but a good opponent will point out that this is just dictum, Your Honor. That's dictum. All right, forum nonconveniens, another fancy term here. This really means there is a better forum or a better court for an issue to be decided. So this, in a sense, relates to the jurisdiction of a court. Is it the best forum? Is it the best venue for a case to be heard? If not, a court or a judge may refer the case out to be heard in a better, more convenient forum. Okay, moving on. Here is gravamen. I love this one. This is, I always think of I don't know why I look at it and I think of caveman, but gravamen. And this may be, this really comes up more in opinions when you're reading case law. The judge may talk about the gravamen of the complaint is this, or the gravamen of the complaint is trademark infringement. So gravamen refers to what is the key point, what is the main point or purpose of the complaint, or it could be some other pleading or other document. What's the gravamen? What do you really, what's the key here? Okay, that's a great term, by the way. So it's another legal term. Let's move on. Habeas corpus. Habeas corpus. This is something you might see on TV. And you may see in a criminal courtroom. But basically this refers to a writ that is filed by a prisoner to see if they are legally being held or detained. And essentially means you have the body. And this, what they're talking to in regards to habeas corpus is they're saying there could be an order that the detaining party, that could be the state government, the prosecutor's office, to have to bring the living body of the prisoner before the court so the court can decide whether or not this person is being legally detained. And you'll see if you look up federal court cases, There's a lot of writs of habeas corpus being filed. It's a bit, I would say it's a business all unto itself. If you really are dead set on doing criminal law, a writ of habeas corpus, there's a lot of those that are being filed. All right, moving on. In camera, what does this mean? No, it's not a photographer's convention. This refers to having what I call it a secret meeting, but a private meeting in the judge's chambers. Okay, this is the opposite of doing something in open court. So you may go back and, to me, this is one of the funnest things that judges do, and I wish more judges did it. A lot of federal judges like to do it, and to me, it's a lot of fun. But you go back into a judge's chambers, and no, you don't pour yourself a cocktail and talk about golf. You get back in there, and they may have some clerks in there, and you talk about the legal issues in sort of an informal setting. And this is what's known as, if the judge orders it, it would be ordered in camera. Okay, there's sometimes the judge just says, hey, everybody back in my chambers, but this is actually in camera. And this is something where for some reason you don't want something to be heard in open court. It could be you have trade secrets, could be attorney-client privileged conversations where you're claiming a privilege on something. So if the judge orders you in camera, an in-camera hearing, in camera in the chambers, boom, that's what we're talking about, okay? Next Latin term you need to know, in personam, in personam. Now you can sort of see the word person, that kind of tips you off a little bit, but in personam, this refers to jurisdiction of a court, to be able to hear a case and to render a decision over a party. There must be in personam jurisdiction. This is what, if you're in law school, this is what we call the minimum contacts. Do you have minimum contacts enough with a certain state or jurisdiction that you can expect to be hauled into court and forced to answer the claims, and gives the judge the power, the jurisdiction to render a decision. So, for example, you could be sued in the Central District of California. You may have a little house up in Kennebunkport, Maine, and you may be saying, why am I being sued in California? I've never been there. I don't have a website. I've never visited there. I'm not, seeking the protection of the forum or the benefits of the state. There's no in personam jurisdiction. So that's another great Latin term. It comes up all the time. A court needs to have the in personam jurisdiction and subject matter jurisdiction. Okay? That's a great one. Here's lis pendens. This one really confuses a lot of people. I've had a lot of pro per plaintiffs and other people call our office. This really comes up in real estate law, but it's a real estate term, which means it's Latin for litigation is pending. Now, some people will call my office and say, I want to file a lis pendens. I want to file a lis pendens. Well, I say, okay, have you filed a lawsuit? Well, no, I haven't. I want to file a lis pendens. I want to cloud the title. And you say, well, lis pendens means litigation is pending. You have to file a lawsuit first. So this is typically just a document that gets filed with your county recorder's office. It clouds the title. So, and I tell people, it doesn't cloud, it clouds the title. It doesn't mean that somebody wouldn't buy or sell the property. It just means there's a cloud, and it means you could have a hard time getting title insurance. So that's lis pendens, another fantastic Latin word you need to know. All right, moving on here. I hope you're taking good notes here. If you get this stuff, you're going straight to the top. Locus delicti, this is a criminal law term, refers to the scene of the crime. Locus delicti, that's a fun one. It just rolls off your tongue. Next one, malum in se versus malum prohibitum. Okay, these again are criminal law terms. Malum in se means it's inherently evil, or it's inherently wrong. So it's like murder. Murder is malum in se. You don't really need a statute to tell you that. You should know that. Rape, mayhem, those kinds of things. They're inherently evil, and those are referred to as malum in se. Malum prohibitum are really just something that is wrong, and I put here due to the legislature prohibiting it, passing laws saying, well, it's against the law to jaywalk. Say, well, I know that's bad, but I mean, is it really that bad? Is it inherently evil? So there's your difference in a nutshell. Malum in se versus malum prohibitum. That would be a fancy one to throw on your bar exam. I would think that your examiner would know that you're really working overtime here, watching Attorney Steve videos. All right, moving on. Motion in limine. Motion in limine, not lemonade. We're not making lemonade here. But this is a pretrial motion. This is really, I'll just give you an example. I used to shadow a criminal law attorney around, and before his trials, he would have these books full of these motion in limines, and the judges don't necessarily love them. They would rather just have the parties do a trial on the merits and go for it. But there are some things that you want to suppress, or you want to stop your opposing party from mentioning the word insurance company, or those kinds of things. So it's a motion that you file pre-trial before the trial, seeking to suppress evidence. Okay, so this comes up a lot in litigation if you're getting into pre-trial, the case is getting ready to go to trial. Motion in limine. All right, this one is per curiam, the next one. So usually you have let's say you have the Supreme Court. Let's say you have 9 justices and it's a 5-4 decision, and you go, wow, everybody's sworn to support the Constitution, but they have a completely different view of the Constitution. Well, such is life. But there are times when a court can come together and say, you know what, this decision's really obvious. We don't need dissenting opinions. We don't need concurring opinions. Let's just issue a per curiam decision. That means unanimous, a unanimous decision of the court, speaking as a whole, as opposed to any individual judge, okay? Per curiam, that's a great one. You see it all the time. Here's another big Latin term, prima facie. Okay, so I have here, for example, negligence. In order to prove negligence, let's just talk about California. You need to show duty, breach, causation, and damages. That's bullet point number 2. And when you're pleading, let's say in your complaint, you need to plead all those elements. You don't need to prove it at the initial stage. You just need to make a prima facie case, or what they say, a prima facie showing that you meet the elements, that you've adequately pled these elements, that they're plausible. And if you can do that, it's prima facie. Your pleading would not be subject to a demurrer or a motion to dismiss in federal court, as the allegations are valid on its face. And that's really what prima facie means, face, valid on its face, okay? So it refers to meeting all the necessary elements of a cause of action, at least facially speaking. Prima facie, you'll see it all day, every day in the practice of law, especially in litigation. Okay, next one is pro tempore. Pro temp, I think that we call it pro temp, or pro tem, sometimes you hear it. Refers to a judge that's appointed on a temporary basis. Keyword here, temporary. Are you catching on to the little tips here? Temporary basis. So your judge could be assigned to a judge pro temp. There you go. Easy, right? Quid pro quo. This essentially means a trade-off. It means this for that. I give you something, you give me that. And this is really important when you're looking at the law of contracts, where you are required to show consideration in order to have a valid, enforceable contract. A contract is a promise or set of promises that the law will enforce. So a quid pro quo, that's your trade-off, and that is the glue that holds together a contract. All right, we're getting near the end here. Quitam, what is this? I didn't know much about quitam or quitam, but I found it fascinating, and I eventually ordered a book on it because it was really interesting. But this is really if you know somebody that's ripping off the government, let's make this as simple as possible. They're ripping off the government, making false claims. It's actually known as the False Claims Act. You can basically go to, I believe it's the Attorney General, United States Attorney General, present the claim to them, and if they want to take the case, you get a percentage. I think it's 25, don't quote me, but you would actually get a percentage of the case while they're prosecuting it for you, while they're bringing the civil action or whatever they're doing to recover. So you are essentially, as bullet point 2 says, pursuing an action for the king and for yourself. So, and as I recall from the qui tam is if the government doesn't want to take the case, then you're free to bring it on your own. So again, don't quote me on this because, you know, this is a area of law all to itself, but it happens to be a Latin phrase. And if you know qui tam, if that pops up in your bar exam and you pull out qui tam, I mean, that's, well, be careful because the bar examiner might not know that one, but that's a key one. It's really a cool word, qui tam. Could make you some money too. All right, this is one of my personal favorites, res ipsa loquitur, res ipsa loquitur. This is Latin for not the thing, it's supposed to say the thing speaks for itself. I must have been getting tired here. The thing speaks for itself, and this is often used in tort law, like a negligence case. The one I remember from law school is some guy is walking underneath a building, a big bag of, I think it was a bag of flour or cement or something. A bag of something fell on the guy's head, and he went to sue for negligence. And the defendant said, "Well, you can't prove who did it. You can't prove which one of us did it. So you got no case." And this is where the good plaintiff lawyer, and this comes up, you got to keep an eye out. This comes up. A good plaintiff lawyer will say, "Well, res ipsa loquitur, the thing speaks for itself, Your Honor." And what this does, this allows a presumption of negligence so that you can get through the motion to dismiss or the demurrer. It allows you to avoid basically losing the case. So this is a really fancy, don't do what I do all the time, try to spell loquitur with a C. I don't know why I do that. It's a mental brain hemorrhage that I have, but res ipsa loquitur, the thing speaks for itself. All right, res judicata, another great one. This just says a legal matter that has been litigated should not allowed to be litigated again by the same parties unless it's an appeal. Obviously, if you go to a trial and you lose, you should be able to appeal. People have appeal rights. But what res judicata says is this case, these causes of action have already been heard. You were the parties. You don't get to go do it all over again just because you're angry or something. So that's res judicata, also known as AKA action estoppel. And then I have here just contrasting this with collateral estoppel, which is what we call issue or claim preclusion. Issues raised and litigated should not be relitigated. So if you lost on copyright infringement, you shouldn't be able to come back and raise the issue again and do it all over again. Res judicata, collateral estoppel, two great ones there for you, 2 for 1. All right, next Latin term you need to know, scienter. All right, this comes up all over the place in law, constantly popping up in civil cases, fraud cases, criminal cases. And scienter basically refers to a full awareness of committing a tort or a crime. So you're fully aware of what's going on. You have the scienter. Some people would call it the guilty mind. Some people call it knowingly, willfully, intentionally. So scienter is that full awareness of doing something wrong is what I would say. Okay, scienter, that's a great word there. All right, we're getting down to the end. Stare decisis, this is kind of what our legal system is all based on, the doctrine of precedent. If we've already heard a case about Roe versus Wade, and we've already established what the rule is, the precedent is what it says it is. It's the trimester approach, as I recall. And so if you have another case that's what we call, quote unquote, on all fours, meaning all the facts are the same, the previous law, the precedent should be followed, and that is what we know as the principle of stare decisis. Once again, deciding cases based on previous cases, okay? That's what we call, that's case law. And subpoena, what is a subpoena? This is another word that people misspell all the time. This is a legal command from a court. This is usually a document stamped by the court or by an attorney directing someone to appear, to testify, or bring documents, or do both. And if you don't follow the subpoena, or you don't work it out with the attorney where you can fix the right date or do something amicable to both sides, this could be punished by contempt of court. So you don't want that. Punished by contempt of court. Court has wide latitude in issuing sanctions and doing what they want to do as far as contempt of court. And finally, there is the motion to quash. Some people like to call, I think they don't know the law, so they're calling it motion to squash, which I think is pretty funny. I like the name, actually, and maybe we should push for that. But there is a motion to quash where you can try to quash the subpoena, and there's a variety of grounds that you can do that. I have other videos on subpoenas that are out there. If you want to watch those might be helpful for you. All right, and we're down to a final one or two, respondeat superior. You can't go through law school, you can't go through the practice of law without this word, phrase, popping up left and right, over and over, up and down, side to side. This is basically let the master answer. Let the master answer, bullet point 3. What does that mean? Basically, it means an employer is liable for the torts or the wrongdoing committed by its employees within the course and scope of employment. The master needs to answer. So this is where you have employees that are doing things. Maybe you have employees posting copyright infringing material online as part of their job. You know, you don't sue the employees, you're going to go and sue the company. The company is liable under the doctrine of respondeat superior. So again, that's a great word. Pretty sure that's going to pop up in your bar exam somewhere, and for sure in the practice of law. All right, that's it. We're a civil litigation intellectual property firm. If you like the video, hit that like button. Don't be shy. It's not going to hurt you. It helps me. It's not going to hurt you. But anyway, our mission here is to make law more understandable and accessible. If you have questions, there's our number. We get a lot of calls, so I'm not always able to return calls, but if you have an interesting issue, and we can potentially, hopefully help. So other than that, subscribe to our legal channel. Hit that button. After all, you get tired of politics at some point, don't you? So, as we like to say here, be smarter than your friends. So that's Attorney Steve, 30 Latin terms you need to know, JD jargon, and we hope you enjoyed that. Have a great day. We'll chat again. Take care now.